today's webinar. My name is Barb Robinette. I'm Chief Marketing Officer for Empyrean. We're really happy to have you all in attendance today at our first Empyrean webinar. Many of you know we were historic Gen X IME and made the bridge over to becoming Empyrean in 2024. And so this is our first webinar under our new name. And with that, today's session is specific to Alaska, but as we had mentioned in our invitation, we believe that what happens in Alaska will likely set the tone for what could happen in other states as well. And Michelle Meshke at Meshke, Paddock and Budzinski is joining us today as our presenter. Michelle is a lifelong Alaskan, born in Anchorage and raised in Juneau. She graduated from University of Oregon School of Law, and her practice has focused exclusively on workers' comp defense litigation. Her prior legal background includes extensive litigation and courtroom experience in insurance defense as an ADA for the state of Alaska, and she represents statewide and national employers and insurance companies. We also are thrilled that she's a founding board member of Kids Chance of Alaska, as Empyrean is a participant of Kids Chance in many geographies as well as on the national level. And she practices before the Alaska Workers' Comp Board, the Appeals Commission, and the Alaska Supreme Court. She's a member of the Workers' Comp section of the Alaska Bar Association and a frequent speaker on many topics in the workers' comp realm for clients. So welcome, Michelle, to this webinar, and thank you so much for being willing to present this on our behalf and in combination with us. So with that, I will turn things over to Michelle.
Right, great. So what we're going to be talking about here today is the recent legislative change focused in specifically on PTSD as it applies to first responders, and we'll talk about who it all applies to. It's largely focused. There still is the same mental health standard out there for other issues. So this is very narrowly focused on PTSD as it applies to folks that we'll further define later in the medical and first responder emergency medicine type of scenarios. So it applies, it became effective January 1st of 2025. And it's important because it does significantly change the standard in terms of mental health and how we are going to address it. And what we'll discuss here today is what the old standard is under mental health or mental claims, and what the new standard is, and kind of talk about ways that we can manage this, how to get the evidence that we need in order to defend it properly moving forward. So we can see if I'm in control of this, or is it Dana's control? Oh, there we go. All right. So the changes that were brought actually came about sort of suddenly within maybe the last hour as the final votes were happening. It applies to mental injuries only to certain categories of employers, but it will impact employers, payers, injured individuals, workers, providers, medical institutions are going to be impacted, and it is already in effect. I have not seen any yet come through, so the sky did not fall yet in terms of what the impact could be, but as people learn about it, then we may start seeing more of these. So let's dig into the changes, and we'll start talking about what the standard is and how to move forward. And an important part of this, of course, with Empyrean is that we will need psychological and psychiatric IMEs to help evaluate what the cause of PTSD is. And in this situation, I'm going to assume everybody knows that PTSD is, post-traumatic syndrome, and that that applies very specifically only to this diagnosis. So kind of we're going to go backwards, and this is going to be review for probably a lot of people, but I want to talk about what the old standard is first, and this is under AS 2330-120, and the presumption of compensability applies once an employee has established a preliminary link between the employment and the injury, and that is basically a nexus of any kind that connects the injury to the work. And it can be as simple as, the employee reporting it, a witnessed kind of injury, a witnessed fall. It could be mentioned, the work event being mentioned in the initial treatment. And as long as it sort of makes sense and a reasonable person could establish that link, then for physical injuries, that is what is required, and it becomes the presumption is that benefits under the Workers' Compensation Act are payable at that point. There just has to be some evidence that the injury is work-related. And Section C is the part that previously applied to, and so let me just also say that that presumption of compensability also applies to mental injuries that arise from a physical injury. So we have two kinds of mental injuries normally. We have a mental, which is covered by 120C, and we have mental physical, or physical mental, where it arises something in the situation where you would have a chronic pain that leads to depression, or the chronic pain and inability to return to work and loss of income, that leading to depression or anxiety. And so those things can be triggered as part of the presumption of compensability as long as it's linked to the physical injury itself. 120C is applicable to mental injuries. That's what we normally characterize them. And the red part that you see that is on the screen, except as provided in AS 2330-118, that's the new part that was added to 120C. But in the past, that section, there was a challenge to whether carving out the presumption of compensability, it does not apply to a mental injury resulting from work-related stress. There was a challenge. This section was adopted in 1988, and there was a challenge to the constitutionality of it, and the Supreme Court did find that it was acceptable because there's a difference in mental injuries compared to physical injuries. But that red part there is what was added to 120C effective January 1st of 2025. So then this is again applies to physical injuries and mental injuries coming from, to establish the presumption, it has to arise out of and in the course of employment, and the employee must establish a causal link. The presumption can then be rebutted by the employer by a demonstration of substantial evidence that the disability or need for treatment did not arise out of and in the course of employment. And benefits are payable if this is where we also find our causation standard in Alaska, that the benefits are payable if the disability, death, or need for medical treatment, if in relation to other causes, the employment is the substantial cause of the disability or need for medical treatment. So that's the old standard. And typically, and again, it does apply to, things like depression that may be resulting from a physical injury. And did I do too many slides? I think I did one extra. Ooh, going all over the place here. So going into a little bit deeper detail on 2330-010B, this is the one that applies to mental injuries, the one that has been changed. And it's fairly specific, and it says that that compensation and benefits are not payable for mental injury that is caused by mental stress unless it is established that, one, the work stress was extraordinary, unusual in comparison to the pressures and tensions experienced by individuals in a comparable work environment, and two, the work stress was the predominant cause of the mental injury. Uh, this is still the current standard for a mental injury that does not involve specific categories of employees who are defined under the new section, which we'll talk about. So this is still an active standard. It applies to basically all the types of employees who are not covered under the new statute 118. And under this standard, the amount of work stress the statute specifically says the work stress has to be measured by actual events. And also that a mental injury is not considered to arise out of in the course of employment if it results from disciplinary action, work evaluation, job transfer, layoff, demotion, termination, or similar action taken in good faith by the employer. But under this old standard, or this standard for the mental injuries that are not related to first responders, the burden is on the employee to show that the work stress was the predominant cause of the mental injury. That means that you can, if it's appropriate, that there's no burden to, automatically pick that up unless you really, as an employer and adjuster, you look at it and you think that, it's really obvious. Like, for example, say a shooting, or something crazy happens at in the public at a, a restaurant or the mall or something like that. That would be pretty obviously an extraordinary, unusual situation. But it gets a little bit more dicey when you get into careers and jobs where people are regularly having some pretty serious situations. For example, correctional officers and police officers, where a lot of those people are going to be in a comparable work environment. So it's a little bit harder to establish. And I think that that's why there has been, why this has come up. And there has been a trend recently in other states. And so this is the new standard that really is specific to people who fall under these categories. And I'm just generalizing as first responders. But a new section is AS 2330-118 was added to the Act. And there is a presumption of compensability for post-traumatic stress disorder if the employee is or was employed in an occupation listed in the next section, B2, and while employed or within the last 3 years after the date of the employee's last employment, that employee receives a diagnosis by a psychiatrist or psychologist of post-traumatic stress disorder. So I would say it would be for only diagnoses happening also after January 1st of 2025. And then it provides that the presumption may be rebutted by a preponderance of the evidence that the employee's PTSD resulted from factors that were not work-related. And that is the language in the statute, which is quite different from other areas in the Act. And we're kind of, why is this coming up right now? And I think it is because of people that are regularly placed in difficult and stressful situations in their work environment, and maybe the difficulty that they have in proving that their work is the predominant cause of their mental injury. And so this has been sort of a trend across the country. There's numerous other states that have adopted this type of thing already: California, Arizona, Oklahoma. There's specifically there's at least 3 states that passed this in 2024, including Alaska, which includes Arizona and Oklahoma. I know it was proposed in other states, including Maryland, and it's already in practice in other states, including California. So the interesting thing about this is that I looked it up, there is no legislative discussion of it. It was literally introduced, it was never discussed in a committee. This is part of a larger package of workers' compensation legislative changes that mostly focus on reemployment issues, a little bit on notice issues, and then this is like, bloop, kind of just input there at the very last minute with no conversation, no record of conversation that I can locate. It was just sort of plugged in. So it makes you wonder, why this wasn't discussed earlier, if this is really where it should have been best, because there really are actually some other categories. For example, with there's presumption applies for several for physical injuries that occur with firefighters, and so it's in line with that standard, which is that the presumption can be rebutted by preponderance of the evidence. So first, let's talk about who is covered by this. Correctional officers, and there's a list of them. Correctional officers, emergency medical technicians, emergency medical dispatchers, firefighters, mobile intensive care paramedics, and that are licensed in the state of Alaska, peace officers, and then there's one that says employees who are certified under state law to perform emergency medical services. And then it says and I'm like, oh, did I make a typo there? But I looked back at what was passed, and it just says and. So that it leads to the next section that says notwithstanding. It says and then it goes to G3, and it says notwithstanding that this applies for a period of 3 years following the last date of employment. So far, this is the list, but this last section in particular could have broader implications. We don't really know. So we look at, some of these definitions a little bit under 118C. So it talks about emergency medical system, and there's a very long definition for that, but it means a system that is basically, even before this, this is just a few of them, but you have to 118C, which is part of the new section, basically says correctional officer is the meaning given in this statute, emergency medical dispatcher. All of these things are given the meaning, but then it kind of gets a little bit broader when you get to emergency medical services system or provider of emergency medical systems. And it says, or employees who are certified under state law to perform emergency medical services. And this section appears broad enough to potentially include home health care workers or medical providers that may not necessarily normally be considered part of the emergency, necessarily a narrow scope of first responders. So we don't really know yet who this will apply to. It also talks about people with fiduciary interest for the provider of medical services. For example, in that middle section, provider of emergency medical services, a person who has a fiduciary position with or fiduciary interest in a health activity, facility, or health agency, or a legal or financial interest in the rendering of any component of emergency medical services. And so this is where we get a little bit concerned about who all this is necessarily going to apply to. So the next issue is then how does the presumption get triggered? And it must be brought within 3 years of the last day of employment. Any psychologist or psychologist, it can't be just a mental health clinician, has to be a psychologist or a psychiatrist, must diagnose PTSD. There is nothing mentioned about a causal link to employment or to necessarily trigger the presumption. That is a little bit different from what is found in, for example, well, in other states, certainly there's other states that require a link to specific events. There is no causal link requirement in this new statute in Alaska. Also, it's a little bit different than some of the presumptions of compensability that apply for physical conditions with firefighters already in the state of Alaska, that refers to very specific conditions, specific time length, specific exposures and diagnoses. So it's a little bit broader in that it doesn't seem to have that. And there's also no length of time requirement spent as a first responder. I only mention this because in other states that I looked at, sometimes they do have a length of time requirement spent for the presumption to apply, that you had to have been a first responder for 2 years or something along those lines. And there's nothing like that in the Alaska statute as well. Normally, under the prior standard, we would rebut the presumption by a demonstration of substantial evidence that the disability or need for treatment did not arise out of in the course of employment. And we have to think, well, what is substantial evidence? And that is generally defined as evidence that, if accepted as true, would mean that the claim is not compensable. And usually we generate this through medical evidence. It can be treating providers, just that there's a different cause that you can see that's in the treating provider notes. It can be medical evidence that is provided with an IME, and that's probably the most common way that we're able to rebut the presumption of compensability. And we cannot do that in these situations. So in this becomes a problem because a PTSD claim for first responders cannot be controverted based on substantial medical evidence. It can only be rebutted by preponderance of the evidence that PTSD has resulted from factors that were not work-related. So that is a completely different standard that we've seen, and it suggests that really, what is a preponderance of the evidence? It's generally, that means that it can only be found by a fact finder, by the person who is adjudicating the claim, the decision maker, and that's going to be the board in our situation. So it's really a situation that once the presumption has attached, we're going to find ourselves in a situation where we can't controvert the claim. If that presumption is attached, unless you go to hearing. And really, it could be, we all know how long it takes for cases to necessarily go to hearing, but we're talking 18 months at least, probably. And so that is similar to the current statute that we have that applies to firefighters, some physical injuries under AS 233121. But in that statute, it actually talks about different kinds of evidence that you can find, like evidence that you can submit. Evidence can include weight, lifestyle, hereditary factors, and that's just generally more specific than the PTSD statute is. So preponderance of the evidence, going into a little bit more detail, it is a standard of proof that requires the party with the burden of proof to show that more likely than not their version of events is true, and it's more than 50%. And so in this case, this party with the burden of proof is the employer. So the employer and insurance carrier would have to establish that it's more likely than not true that factors other than work are resulted in let's say, that factors that were not work related were the result, is what resulted in the PTSD diagnosis. So, how are we going to show that? And we're going to have to go to hearing on this issue. So that means that we're going to have to develop evidence for that information. I think you have to start at the beginning on how to defend this. And if somebody makes one of these claims, you have to do your best to try to get recorded statements and statements from witnesses that may know about an employee's past or other events going on in their life or that they've experienced in their life. You would rely on, and really a lot of that's going to be based on statements, by the employee themselves, self-disclosing prior conditions, prior events in their lives, very personal information like prior abuse, sexual assault, those types of things that may have established a prior diagnosis of PTSD. And then ultimately, once you gather enough of that information and records, then you would want to be presenting that information to a psychological or psychiatric IME to evaluate the cause of the PTSD. And again, the standard is you have to show that it resulted from factors that were not work-related. And so, you could be going back to childhood, you could be going back to, way far in people's history and psychological evaluations or psychiatric evaluations are going to go deep into that type of history. And I think what we're hoping for um, is that we'll be able to get that information from IMEs, but those can be um, quite expensive and they're a little limited in nature. So I'm hoping Empyrean is planning on bringing up some psychologists and psychiatrists to be able to give us that information. Oops, sorry, backed up. So just to kind of summarize and recap of it, the presumption will attach for nearly all first responders who get a PTSD diagnosis by a psychologist or a psychologist within 3 years of employment. So it casts a very wide net. There's no requirement that there be some specific triggering event that caused a PTSD that was work related, just that it was diagnosed. And then there's going to be a lot of work to do to dig into that person's past history to determine whether or not there are factors other than work that contributed to or caused this PTSD diagnosis. And because this is so new, even on a national scale, how this plays out sort of remains to be seen. So far, there has been, you know, I'm not aware of any cases, and I've talked with other attorneys at my firm that have seen this claim come about, but it could impact hospitals, home health care, municipalities, you know, certainly boroughs and things, school districts that could even apply. It just kind of depends, um, what people's certifications are and whether or not they fall into those categories of employees that are sort of need to be a little bit further argued about in terms of whether or not they're sort of caught in this broad net. So we'll see how that goes. We're very new into this, just a couple months in, and so I'd be interested to hear if anybody's had any experience yet who are dealing with directly with employers. So with that, I think we'll turn it over to see if there's any questions.
And they're flowing in.
Oh,
So a
great.
couple questions that came up surrounding, it sounds like from what you said, Michelle, it does impact staff within hospitals, nurses and physicians. Is that correct?
Interpreted to be so. Yes. I mean, some of those definitions, particularly it could do that. I mean, I think there's room for argument on that, and that there are probably going to be some challenging cases where, maybe, people who are more in administrative roles and not normally, because I think the intent was to catch people who are certified by the state of Alaska to provide emergency medical systems. But then you get down to some of these they refer to these statutory definitions and you get down to those and it gets a little bit broader. And so we're
Sure.
not sure yet how that's going to be interpreted.
Sure, because what came to mind for me was, does it also mean that nurses and physicians and potentially other certified first respondent type staff in the ER, but what about when the patient, is still being exposed to people in other departments within the hospital if they are admitted and so on and so forth? So,
Mhm. Yes, I mean, I
okay,
think it does have it could have a very broad impact on who's covered. And that, I guess, is probably, I'm going to just say kind of a result of something getting thrown in at the last minute where there really hasn't been discussion about who is intended to be covered for it. And so I do
right.
think there's people that, could potentially, and all you have to show is you were employed, you know, I mean, I'm sure that there's people, it's not just EMTs, it's medical providers, nurses, people who've been, what about somebody is certified and has a certificate and been approved to provide first aid. It's anybody in these potential categories. And so we're not really sure how far it's going to go, how people will know about it and learn about
Hmm.
it.
Right.
But certainly nurses are well within the range of people who could be making these claims.
Sure. And then you mentioned something about firefighters. So was there a different type of regulation already in place for firefighters, or did I
Not
misunderstand?
not in Alaska, but I looked for the PTSD in other there's for firefighters, we already have in our statutes presumptions for it's under AS 2330-121, and it's a presumption of coverage for disability from diseases for certain firefighters. And so that particular statute goes into certain very specific diagnoses that are physical. And then it also says that this presumption of coverage may be rebutted by a preponderance of evidence. And so that actually is the same standard as PTSD, but it says
Mm-hmm.
the evidence may include use of tobacco products, physical fitness, weight, lifestyle, hereditary factors, exposure from other employment and non-employment activities. And then there also is a little bit more specific requirements, like you need to have a qualifying medical examination upon becoming a firefighter. And then it talks about that it applies to really specific sections or certifications as a firefighter. And then, it has broad sections that take it out. For example, it doesn't apply to a firefighter who develops a cardiovascular or lung condition, who has a history of tobacco product use. And so it kind of just more specific. And I believe other states have honed it down a little bit more as well. And so that's sort of where, here it doesn't tie to anything, any specific event or
Right.
other than 3 years, which is actually longer than some of the other statutes that I've seen in other states. Some are limited to 2 years. Um, so, but just, I think it's the definition of emergency medical services that could really broaden it out to apply to
Sure.
staff workers.
Sure. Okay, great. All right. So, one of our attendees asked, is it correct that we cannot deny the claim without a hearing?
It appears to be that way, yes.
Okay, great. And then another one of our attendees asked whether or not a single IME would be enough for the IME provider to diagnose PTSD, or if there are cases where multiple IMEs might be needed to address the psych issues.
Yeah. I want to go back to that other thing about can we deny a claim? I mean, you can deny a claim if you don't think that the presumption has triggered. So I wanted just to clarify that. Like, for
Okay,
example, there was not a, they weren't employed within 3 years or some other,
right.
it's pretty broad to trigger the presumption. So I would say once the presumption is triggered, then you are more than likely going to have to go to hearing. And the
Okay,
next question is whether you need one IME or multiple IMEs. I don't think that there's any requirement to have multiple IMEs in terms of the diagnosis. I think that to establish the diagnosis, I think that once you have an IME, the PTSD diagnosis it should have already been established by a treating psychiatrist or psychologist. And so
right,
what you're looking for is, what is that diagnosis? What is the cause of that diagnosis? Is there evidence of um, you know, past PTSD diagnosis, past events in the life that would have resulted from PTSD? I think you're going to have
right.
comprehensive psychological or psychiatric examination, but I don't think it necessarily has to be multiple examinations. I mean, one of the good things about that isn't a lot is that it is that at least this diagnosis has to be of PTSD has to be done by a psychologist or or a psychiatrist. And I think that's important to distinguish between a mental health clinician that has much less schooling. And oftentimes you hear, PTSD being diagnosed, for things that are not really a near, you know, a near-death experience, or it gets pretty broad, and people, it's one of those things that's been broadened enough where people will say, oh, I got PTSD from X, Y, and Z happening, but you're not really talking about the diagnosis. It's like and so at least making it be required by somebody who actually has to go through all the diagnostic tools and the access and all of that, that's important, because I think that there's a lot of clinicians out there that may just put that label on things, and then the next thing you know, it's just assumed without any
Correct.
psychological diagnosis.
Yeah. Yeah, I think that we're all well exposed to it becoming part of typical jargon, PTSD, anxiety, where people might have just said, I'm stressed,
Right.
in prior lives.
Mhm.
Okay, our next question says, is it okay for these psychological, psychiatric IMEs to be done remotely so that the providers don't have to actually be in the state, especially since it doesn't necessarily, it's not hands-on?
Who's that question from?
One of our attendees, Rose.
Okay, hi, Rose.
Mhm.
Yes, I mean, I think that if they have to be licensed to be in Alaska to do an IME, I believe.
Okay.
So, but can it be remote? I mean, I suppose I don't think there's anything that prohibits it from being remote.
Okay.
Um, and we've definitely had that in the past where we've had remote psychiatrists participating, but they would still need to
Oh,
be, meet the requirements
the
under.
licensure. Okay, great. And then Susan asked us, what if the employee gets a PTSD diagnosis from a physician? Can we controvert based on that? If so, what happens if they then get a diagnosis from a psychiatrist or psychologist? Okay, so I think the variation is if the employee gets a PTSD diagnosis from an MD versus a psychiatrist psychologist.
Okay, well, I think this is also a similar situation that happens is just we're probably talking more about like an internal medicine doctor who is like, oh, it sounds like you have PTSD. That's a medical doctor. That is not the presumption of that's not triggering the presumption of compensability, and I would controvert based on the fact that there's no diagnosis. If it's from an MD who is just like an internal medicine doctor or family medicine doctor, that's different um, than having and so a psychiatrist is an MD. They're all MDs. So to be a psychiatrist, you have to be a medical doctor, and a psychologist is a PhD. So the
Hmm.
diagnoses have to come, but they have to be specialized in psychiatry. So
Okay.
it would not be, an internal medicine doctor or any other type of doctor who just colloquially says, "Oh, sounds like you might have PTSD." You know,
Yeah.
"Yep,
Ahmed, family
here,
practice.
Xanax," but I think you could go and cure that. You could cure that controversion by going to a psychiatrist or a psychologist to get the diagnosis.
Okay, great. And then Jody mentions, as you know, in Alaska, employees are required to sign a medical release or a denial can be issued. If an employee does not sign the release for these types of claims, can a denial be filed on that basis?
Um, I think that yeah, I think that there's no exemption for it. They would have to still file a release, and you need to make sure you're getting a mental health release because there's specific language in a mental health release. A medical release does not apply. The normal, the most basic release that is, provided, I think even as might be under the report of injury or one of it's almost automatic that we get these medical records. I think it would be a mental health release needs to be sent out to the employee that's specific to that, that meets those requirements. Otherwise, you might not be getting the medical records. And then the other trick I think that's going to be a problem is there's a lot of mental health providers that will not accept workers' comp insurance from the get-go. And a lot of people and so then that's how a lot of times adjusters get records is because they want to get paid, so they have to provide their medical records. Um, and then, I mean, I've seen some recent clinical notes, and boy, that can be pretty messy in terms of their handwriting. But it has to be, it should be a psychiatric or psychological evaluation that gives that diagnosis. But they're going to have to release that information to you before you can, in order to trigger the presumption of compensability. Because if you don't
Right.
have that diagnosis and documentation of that diagnosis, um, then I don't think it's enough for the employee to say, "Oh, I got diagnosed." I think
Sure,
you.
sure.
Mhm.
And you did mention home health. So the question that came from Patricia, one of our attendees, is can this apply to home care staff as well? So I'm thinking she means home health personnel.
Well, I think it depends if they have been, like emergency medical service under AS 2330 200. It says emergency medical service means the provision of emergency medical care and transportation of the sick and injured. So it kind of depends what could fall under that, but it depends
Sure.
individual certifications are for people as and what their job duties are.
Hmm. Okay. Um, Vicky asks us, she might have missed it, but she's curious about fellow employees who have to give life-saving measures until first responders arrive, or does it only apply to a certified medical provider or caregiver?
I I would say that it would not apply to somebody who's not certain that doesn't specifically fall into one of these definitions.
Okay.
Um, a a run of the mill, regular North Slope worker who sees their buddy go down and they have to give emergency medical services. If they don't have, if they aren't licensed by the state to provide emergency medical services, then that would fall probably under the mental standard of care, which is still in existence, that 010B section that talks about the extraordinary and unusual stress. And so, but that's also a situation that, you would evaluate as an employer to see, does that fall in that situation? But
Right, right.
the standard, it would not fall under the first responder unless they actually fall into one of those definitions.
Because it sounds to me like, Michelle, like what you're saying is in this first responder category, it's you have a diagnosis of PTSD and you are in that kind of a role. It is not your duty to prove it. Whereas if you're not a first responder, there's more
You have to show
provision of information.
you have to prove it, or a lot of times, I mean, employers and care adjusters will accept those type of claims in extreme situations like that. Like
Mhm.
if, and it's just somebody who would not normally be exposed to those kind of conditions in their normal work, but something out of ordinary and extraordinary and unusual happens, and that can be lead to a mental injury that's covered under comp. There's no presumption of compensability, but certainly it's within the discretion of the employer to say, "Ooh, this was bad," and
Right.
we want to provide this to our employee.
Right.
Um,
I've been exposed to, crisis response programs that are used in those situations where there's a major incident in the workforce and they bring in counselors to help with all the surrounding employees and such. So
yeah,
one of our participants named Anne asked, why can't we deny a claim after an EIME? I don't know if she meant IME or if there is actually a term EIME.
I think
That,
it kind of means employers IME, so it means
okay.
all IMEs that we get through
That
any
was
benefit.
new for me.
Yeah, yeah. A lot of times people it gets thrown around that it's not an IME, it's a employer's IME. Um,
Okay,
so, but why can't you? Because it has to do with the preponderance of evidence. The standard isn't under the normal preponderance of the normal way that we rebut a presumption is by substantial evidence or substantial medical evidence. And that is what we get through an IME. The standard under the first responder section is you can rebut it by a showing of preponderance of evidence. And that is a standard that is a burden of proof standard to the trier of fact. And so it would be like the civil court, or in our case, the board. And so
okay,
there's no way to show by a preponderance of the evidence because there's no one making that, like the IME is not in a position of determining facts.
sure.
They're giving opinions. And so the person who's deciding the facts is the board. And that's why a controversion is not going to be able to be done based on IME.
Right. Okay.
You still need the IME because you're going to go have to present that at the board, but then it's sort of at the board that everybody has to meet their burden of persuasion of the board. Like, did, has the employer met their burden of showing that, this is not, it's the PTSD diagnosis is because of other factors not that are not work related. Has that
Okay.
You need an IME to show that.
Sure.
The other
Sure.
thing is in Alaska, of course, we're going to end up going to SIMEs, which are really sketchy and expensive. And, and I don't know if anybody's had any recent experience with them, but, my recent experience has not been great. And so that's going to be tricky too.
What does SIME stand for?
SIME is when we have a treating provider and an IME have a dispute, there's a difference of opinion, then the board will order a second independent medical examination. We call that a SIME. And
Gotcha.
and so then it goes out for sort of a third opinion, if you will.
Gotcha. Gotcha. Okay. And then the last question that I see here, and I actually might have, no, I think that this is the last one. How do you develop a preponderance of evidence without using more than one IME and using your one physician change?
Um, well, that goes to the burden of persuasion. So, I mean, there's the burden of, I mean, it really comes down to what's your evidence? And I mean, I think that depends on completely what your facts are. Um, but, um, there's you can prove your case or lose your case, on one IME now. So there's no
Right.
difference just because it's PTSD that you would need any more evidence. You're still going to need to have evidence, and you have to build that up through statements of the employee, statements of family, disclosure, the psych evals to see what the background is and show the other factors. Was there a prior diagnosis of PTSD ever in this person's life before they became a firefighter or whatever? So
Right.
those all have to do with, I think, the burden of persuasion and convincing the trier of fact that you have met your um, burden to rebut the presumption of compensability.
Sure, sure. Great. Well, I appreciate all of the answers, and I think we got through everyone's answers here. We want to thank everyone for attending. We obviously want to thank you, Michelle, for imparting all of your knowledge on us. We hope that everyone found the session informative. We would really appreciate it if all of our attendees could respond to the survey. They should be available in the lobby of the meeting, but they'll also probably be emailed to you all, but that will really help us in scheduling future sessions. Please keep in mind that our annual calendar will be published soon. That will take us through the end of 2026. We're going to publish an 18-month calendar, and our first webinar slated for mid-June will be on the topic of concussions. So that will wrap it up for today. We've got a lot of compliments to you, Michelle, and thank yous coming in on the chat. So thank you again for joining us and helping us understand the PTSD changing regulations for first responders.
Thank you.
Thanks so much. Have a great day, everyone.